One of the properties that's going to be auctioned off today, the old Carrollton Courthouse, has been subject of print and TV media over the last 2 or 3 days. One of the issues that's come up is whether or not the property has to, in perpetuity, remain used for school purposes or as a school facility. To give you just a brief history lesson, prior to the 1950s, many of the school properties in Orleans Parish were titled in the name of the city of New Orleans rather than in the name of the school board. There was a constitutional amendment passed in the 50s which mandated that all those properties be transferred from the city of New Orleans over to the school board. Mayor Morrison was the mayor of New Orleans at the time, and the city of New Orleans refused to transfer the properties over. There was a lawsuit filed in the Civil District Court for the Parish of Orleans, which ruled in favor of the Orleans Parish School Board and declared that any properties that had been dedicated exclusively for school purposes had to be transferred to the Orleans Parish School Board without the necessity of payment of any funds for that transfer. The Civil District Court decision was affirmed by the Fourth Circuit Court of Appeal. What has come up is language in the deed affecting the Carrollton Courthouse property to the effect that it says that all the above property transferred is dedicated exclusively for school purposes. We've looked at that in the past where properties such as this have come up for auction, and our opinion has consistently been that that was a description of the property that was mandated to be transferred. It was not a restriction on the deed. Further, our opinion has stated that if property is no longer necessary for a public purpose, unless there was a revisionary clause in the act of transfer, there would be no need for it to either go back to the original owner or to be basically kept in a situation where it could not be used for purposes other than school purposes. So I hope that my remarks in some way clarify what the controversy is and basically highlights the fact that there really is no controversy. I think people have picked upon language in a deed that was designed merely to indicate what properties were subject to the court directive and the constitutional mandate for transfer. Today's auction is the first time that these properties are offered under state law. The minimum bid must be not less than 85% of the appraised value of the properties. Sir?
Are you saying you're going to issue a title, a clear title of this property without that restriction?
What will happen is that once a successful bidder is announced, an agreement of purchase is entered into. At that point in time, title exam will be conducted, and I presume that clear title will ultimately be able to be transferred. If it's not, then there won't be a transfer. But the agreement basically provides that the school board will transfer the property as is, where is, the only warranty being warranty of title. If it cannot convey title, then the purchaser would get the deposit back. But let's assume that we'll be able to get past the title.
We're assuming that it doesn't have to be a school.
What will happen is this, is that whatever title policies that would be issued or whatever, if there is a restriction, it would note the restriction. Historically, we've had this issue come up with similar properties, and the underwriters have not deemed it necessary to impose such a restriction.
Well, I bought the last property, and that restriction was on the property. My lawyers here, just making sure that if I bid on it and I'm successful, that there's not going to be a restriction that it has to be a school.
Well, let's take that step when we get there. At this point in time, our opinion is that any language suggesting that it has to be a school is not a deed restriction. And I see you're a lawyer there from Adams and Reese.
I think this is a fair question. The question is Bayou Title willing to write a title, or is able to write a title policy without an exception to that restriction in the policy? That's a simple question.
And the simple answer is that once the matter is given over to them to review title, we will see what they say. But at this point, I don't anticipate there being a title restriction. about the best I can do. I can't really see into the future. But as I said, the issue has come up before, and I think that the better reasoned view is that that language that was in the deed is not really a deed restriction, but Mayor Bailey was in there to basically describe what properties were being transferred and why they were being transferred. And I think you're familiar with the deed itself. I think right above that language, it recites what happened with the court case, the Constitution, et cetera. Mr. Cummings?
How are you?
Fine, sir.
That's an important question, I'm not sure it was answered. And that certainly would dampen the enthusiasm to bid high and send a lot of money to the school board if it's not clear today and now before we bid as to whether or not there's any chance that this property will be required to be a school.
And my answer to you is that my opinion is that the language that was noted by the news media, in my opinion, is not a deed restriction. Now, can I guarantee you that somebody in the future, some court or whatever, might conclude otherwise? No, I'm not gonna stand here and tell you that, but in looking at the history of the properties, et cetera, and the fact that there is nothing in there that would, in my opinion, amount to a deed restriction, there should not be an impediment. Now, in terms of any loss you might suffer, if there was an impediment, you get your deposit back. So there's no loss to be obtained regardless of the outcome. But as I learned from you when you taught me workers' comp about 40 plus years ago,
It was my best student.
I never deal in absolutes. Okay?
Hey, Bill, look,
If it's still there, if it's not clear, for example, would you assume that you would transfer title? Will you put that in the title, that it's just what you said, and that it was never intended to be a restriction on the title?
Well, let me say.
Tell us that you will do that.
Well, let me say this, if the parties to the transaction both agree, seller and purchaser, to include that, I see no reason why it could not be included.
Will the school board agree to that?
That's a public matter that I don't stand here to predict what they would do, but my recommendation would be to them that they would include the language.
hey, Bill, just FYI, on the Noka building, it took us a long time to get the title insurance company. In fact, First American wouldn't write it. We had to go to Chicago title.
In fact, as I recall, I participated in getting an underwriter to basically conclude that it was not a deed restriction. I think the ultimate act of sale was passed by Adams and Reese, who dealt with the title company. But I think your counsel will acknowledge the fact that I worked diligently to get an underwriter to basically say this was not a deed restriction. Based on that, I can stand here before everyone here and say that we did have precedent for this specific situation, and we did find an underwriter willing to recognize the fact that that was a description and not a deed restriction. Anyone else? Okay, that being done, turn it back over to Gilmore.